Recently, a constitution bench of the Supreme Court has delivered an important judgment on what is known as passive euthanasia and living will. Now, euthanasia, active and passive, means the following. When a person is in a medically compromised situation and he feels that he is in great pain and has no hope of recovery, and thereafter, if he wants his life to be ended painlessly and quickly, he can ask, and if he asks a doctor to give him a lethal injection which will end his life quickly and painlessly, that is known as active euthanasia. However, passive euthanasia is a situation where the person does not ask the doctor to give him an injection or a lethal injection, but just asks the doctor not to keep him alive through a ventilator or any other artificial means. That is called passive euthanasia. If he is not in a position to make that call, and if he is in a coma or unconscious, and if his relatives or his doctors make that call, that is, remove the ventilator or life support systems and thereby permitting him to pass away, that is called passive euthanasia. A living will is a situation or an instrument by which you give or you express your wish in advance that should you be in such a situation in future where your life can only be prolonged by artificial means, and that there is, the medical opinion is that there is no hope of your recovery, there is no realistic hope of your recovery, then you do not want to be kept alive by artificial life support. That advance directive or a will expressed by a person to this effect is called a living will, and it is something which is recognized in many countries. Similarly, passive euthanasia is also legal in most countries. Active euthanasia, however, is legal only in few parts of the world. The advantages of a living will are obvious, that one can express this will, your own will, in advance, that you don't want to be kept alive by artificial means. Now, in this judgment, one of the propositions laid down by the Constitution bench of the court is that every person is the master of his life, and therefore he has every right to decide to refuse any kind of medical treatment. No form of medical treatment can be forced upon a conscious and fully sensible adult without his wish. That would amount to assault and battery, which is which is a violation of your rights. So therefore, building on that proposition, the court has said that yes, living will should be allowed, Because if a person has expressed his wish very clearly that he does not want to be kept alive through artificial means, if such a situation arises where doctors are of the view, or medical opinion is of the view, that there is very little hope of his recovery, of my recovery. So, on that basis, the court has said that this instrument of living will should be allowed. The only thing that they have said is, or they have put some safeguards for this by saying that, well, first the hospital where that person is has to constitute a board of 3 doctors of different specialities who should certify that there is no hope of recovery. Thereafter, there has to be a district board constituted in every district by the district magistrate of 3 doctors who should also certify to that effect, and thereafter the advance directive or living will can be executed. The same safeguard has been made applicable even for passive euthanasia, where a person is conscious and says that he does not wish to be kept alive by artificial, or rather where a person becomes unconscious and his family has to decide, or the treating doctors have to decide. The same kind of safeguards have been made applicable for that. Of course, if a person is alive and conscious, he can certainly refuse treatment. Now, the earlier judgments of the Supreme Court was a judgment of Gyan Kaur, which said that the punishment of attempt to commit suicide, or abetment of an attempt to commit suicide, or an abetment of suicide, that is an offence and it cannot be struck down as being unconstitutional. In this Constitution Bench judgment also they have said that suicide or the attempt to commit suicide would continue to remain an offence. Essentially, what this court has also affirmed in this Constitution Bench judgment formally, that once the process of death has commenced, then it is your right to smoothen that process of death by having either passive euthanasia or implementing the living will. So the central government took a stand that while they agree with passive euthanasia, which is what the Law Commission had also recommended in its 241st report, that passive euthanasia should be legalized, because otherwise doctors who switch off the life support systems are always under a fear that they might be prosecuted if they switch off the life support systems. But the government said that while they agree that passive euthanasia may be legalized with certain safeguards, they felt that the living will should not be legalized. The Aruna Shanbag judgment, which came in the context of this lady who was originally a nurse at a hospital in Bombay and who had been in coma for the last more than 30 years. The issue of passive euthanasia arose in that case, and the Supreme Court in that case had said that yes, if the doctors of that hospital felt that yes, her life, that she was more or less a vegetable and there was no hope of her revival, then they could switch off the life support system. However, the doctors in that particular case did not agree, and thereafter, so the life support systems were not switched off, but thereafter she did pass away a couple of years or some months after that. But the court in that case had virtually, in Aruna Shanbag, legalized passive euthanasia with these kinds of the same kind of safeguards which the Supreme Court has laid down in this case. So there was one old gentleman, Mr. Saxena, whom I knew from Palampur. He came to me and he said that he wanted to execute a living will, and he told me what the living will was and what the concept was, and that it was legal in many countries and in the US, etc. And thereafter, because he also knew the then founder and director of Common Cause, Mr. H.D. Shori, he spoke to him as well, and Mr. Shori then spoke to me, and it was at that time that we filed this petition on behalf of Common Cause by studying and researching the situation as it exists in other countries, particularly in the US, where living will is allowed in most states there. So they have declared that firstly, everybody has full authority on his body, meaning that though he does not have the right to commit suicide, but he has the right to refuse any kind of medical treatment that he does not agree with. Secondly, that if he is not in a position to, that if he has a right to express his view in writing in advance, that should this situation arise where his life can only be prolonged by artificial means and there is no hope of his recovery, then he should not be kept alive by artificial life support systems. And that will would have to be executed subject to safeguards, a few safeguards of getting opinion of medical panel at the hospital and at the district level. Thirdly, that passive euthanasia, that is, if that person is not in a position to express his wish, but if his family and his doctors feel that his situation is such that there is no hope of his recovery and that his life can only be prolonged by artificial means, then even his family and doctors can take that decision, but it would have to be approved by that same medical panel. Lastly, they have said that active euthanasia is not legal, and of course there is no right to commit suicide, and that suicide or abetment to suicide would still be punishable. So they said that the right to live includes the right to live with dignity, and therefore the right to live with dignity includes the right to die a dignified death, and therefore it includes the right of any person to decide that he wants a dignified death, and therefore he does not want to be kept alive and have the indignity of being kept alive by artificial means when there is no hope of his recovery.